Okay, it's 8:30 p.m. And welcome to an introduction to criminal law, J150, and we're at week 8. Week 8. This is quickly going by as the quarter moves. You will note that this quarter has moved very, very fast, and so I'm going to go ahead and get started. So I'm going to share my screen. Okay, and again, familiar screen that you're looking at, which tells who I am, my phone number, and again reminds you that you can email me, text, or phone me any hour of the day except the 25th hour of the day. And then also a reminder that you are required to conduct research for all papers. And that means that the sole source of your papers can't be the textbook. And if you do, you'll lose 2 points, which I've indicated to those of you who have done that. All written assignments should be in APA format. That means citations in the body of the paper and references at the end. And then I also want to remind you, I encourage you to use Grammarly, run your papers through Grammarly to make sure that you are not including too much of the material of your sources of your research and not enough critical thinking, because the essence of your assignments is your critical thinking. Okay, but again, our lectures, this is week 8. We got one more in week 10, and then the lectures will be completed. So let's take a look at our announcement. Defenses to crimes, chapter 14 of criminal law and procedure. You know what? I don't think I sent you the PowerPoints for this, but at any rate, I will be sending the PowerPoints after this. Or maybe I did. Maybe I did send them. Let me check to make sure. I think I did. Let's go over and look at the course messages, and it will tell me right away. Yep, I did. I sent you the PowerPoints on Saturday. So you should already have them as well. Okay, so anyway, getting back to our announcement for the week, you're going to read chapter 14 of criminal law and procedure and complete the activity defenses to crimes. And then your discussion post, stand your ground, which we'll do tonight at 11:59 p.m. Central Standard Time for your initial posts. And then you already know the procedures and rules about your posts. I have sent you comments letting you know when they were lacking in information, details, and content. And I had given you a rubric at the beginning of the quarter. And then on Saturday, 11:59 p.m., your reply post is due. Finally, your written assignment is insanity. And that's one. And then your course project is defenses. So now remember what I said, that starting at week 8, week 9, week 10, week 11, you will have not just written assignments, but course projects in addition to the quiz every week. Okay, and it's like that because you don't have a final exam or you have a midterm exam in this course. And I remind you that it's time to finish strong. It's time to finish strong. And then, of course, my motto, adversity is the springboard to success. Let's take a look at what the calendar says real quick. Okay. Okay, no, that's wrong module. Let's go down to here. course tools. Here we go. And here is your calendar, which shows what the assignments are for the week. And again, your reading assignment, your initial post, and your reply post, and then written assignment, and then your course project and the quiz. Okay? So very important that you complete all of these. And I've already said it before, and I say it again, I recommend that you do the 10-minute quiz on the last day so that you can go through all the materials so that you can score well. And then, of course, you're reminded that when you take the quiz that you shouldn't have materials up. You're on your honor when you do it. But if you're trying to search for information, you're not going to be able to have enough time to finish all the questions anyway. So, so that's that. So now let's look at the actual module. And again, very quickly, the written assignment. Note that the written assignment involves 2 to 3 pages, and you're going to address these issues right here. Don's lawyer alleges that Don was not guilty of reason of insanity. What is the defense of insanity? How would it apply to Don if it does? What does Don have to prove at trial in order to be successful? And what does the government have to prove at trial to negate that? So remember, you're going to have your APA citations and references. Remember the rubric that I gave you earlier in the quarter to let you know each week how each assignment is graded. Make sure that you follow that as well. And 2 to 3 pages means that, not counting the cover sheet and the reference page. Then, of course, your discussion post, stand your ground, and then your project. This, too, is 2 to 3 pages, and discuss the various defenses that are applicable to the party. Self-defense, justifiable use of force, and how stand your ground will apply to Alan and Betty, if it does at all. And you're going to take these facts and then you're going to apply them. Remember, 2 to 3 pages means 2 to 3 pages. And again, I repeat, with citations in the body and references at the end. And then, of course, you have your quiz. Remember, I said, by starting this quiz, you agree to abide by the academic misconduct policy set forth in the syllabus. You acknowledge that your failure to do so could result in being expelled from the course or receiving a 0, not just for the quiz, but for the whole course. So that's why I said you should be studying before you take the quiz and not have the information in front of you. And that is also why I said I recommend that you do it at the end of the week. So let's look at the lesson content before we get into the lecture. We're going to cover the issue of self-defense and some other issues. Again, I gave you your assignments already in reading. And then take a look at this. When I say read defenses to crimes, it gives you an understanding about the capacity that's involved and the different rules that are used for insanity. These are important for you to be aware of for one of your assignments. And in addition to what I'm going to talk about during the course of this lecture tonight, self-defense as well. What is entrapment? Okay. And then complete the activity about these things. In other words, you can take a look at the voluntary intoxication, a defense for a specific and intent crime if it negates the existence of the element of the crime. So anyway, you flip it over, and there it is. Then you go to the next one. Okay, you flip it back over, and then you go next. Infancy. It tells you what it is. You can flip it over, and you'll see what's up here. So if I flip it over, it tells you a defense to a crime because the defendant lacked the capacity based upon their age. Many states have abolished this defense, and you know why? Because many juveniles are committing major offenses, and you know that a lot of crime is committed by youth at this time. What duress is, and so I'm not going to go through all of these. So you go through those, and it gives you the answer to the questions and things that you need to know. Okay, so with that, I'm going to go to the actual PowerPoint. Criminal responsibility and defenses, chapter 14. And so I'm going to go through and comment about these. Now, it says here in our initial PowerPoint here that individuals are held accountable for their actions. And criminal responsibility, it says, refers to a set of doctrines under which individuals are held accountable for the criminal acts that they commit. And in English, common law is based on justification and maybe some defenses that were involved. Mistake of fact, self-defense is one of the possible defenses. And so the Fifth Amendment, though, furnishes immunity defense and double jeopardy. In other words, Fifth Amendment says that one does not have to testify against themselves, and double jeopardy means you can't be tried for the same offense twice. Now, you can be tried in state court and federal court, but not 2 times in a row. An example is there was a movie out called Double Jeopardy some years ago with Ashley Judd in it, and she was charged with killing her husband, and she went to prison for it. And then she was paroled and released, and she went out seeking because she didn't think he was actually dead. Well, her investigation uncovered the fact that he was alive and that he had relocated and changed his identity. And so her parole officer, who was Tommy Lee Jones, was trying to catch up with her, and she ended up in New Orleans. Well, and the story goes that she found him, and then he attempted to kill her because it uncovered the fact that he had committed fraud and also defrauded the insurance company and all kinds of things. There were all kinds of things that happened. So he had faked his death to get with another female. Well, the long of the story was that when he tried to kill her, there came a point where she actually did shoot him. And when she shot him, the police said that she wasn't going to be able to be tried because she's already served for this offense, even though he wasn't dead the first time, but he's dead now. And so they couldn't try her a second time. And that's what double jeopardy is all about. So, in other words, the prosecution doesn't get 2 bites of the apple when a person is tried. Now, that does not mean that when the prosecution appeals an issue and they lose, that they can't appeal it to a higher court. But if a person they've already tried, they were found guilty, then that person can't be tried again. Now, if a person pled guilty, and then it's brought out that evidence that there was coercion, then the state has the option as to whether or not they're going to bring another trial. But remember, I'm referring to only instances where the individual was fully tried and was found guilty by a judge or a jury, and then later on someone tries to try him again for the same thing. There are negative defenses and affirmative defense. In a negative defense, you deny you did it for whatever reasons. Maybe you say an alibi, you have an alibi, you deny it. The prosecution lacks sufficient evidence of your guilt. There is an alibi. Or the prosecution must prove guilt beyond a reasonable doubt. That's the standard in criminal cases, as opposed to in civil cases by what we call the preponderance of the evidence. And reasonable doubt is kind of like saying on a mental basis that there's enough evidence gathered that would point to you so much about the commission of the offense that there's no doubt that you did it. That's kind of like the way it's put. With affirmative defenses, now with preponderance of the evidence, it is based on the majority. So let's say, for example, if 50% of the evidence points out, 51% points out that you probably did it, and 49 that you didn't, then you probably would be convicted under the preponderance of the evidence. Defense admits in an affirmative defense, but denies responsibility, such as mental capacity. Insanity is mental capacity, diminished capacity, or infancy, as we said already, or self-defense. There was a justification or excuse, or that the person lacked the capacity, as I said earlier. But the defendant has the responsibility of providing that affirmative defense by a preponderance of the evidence. In other words, it must be that it appears that, like I said, over 50% of the evidence points to the fact that that individual was justifiable, or that person was mentally incapable of committing the offense. And you're going to find that when we start talking about mental capacity, such as insanity, that it's a toughie. It's a toughie to prove. And most of us defense attorneys will tell you that it's not very, very easy. And we're going to cover that in a little bit. Okay. Lack of capacity. Again, as I said at the outset, it's not really a big issue, but there are certain age levels, such as children under a certain age are not able to form criminal intent. Under the common law, the age was 7, but since we didn't have juvenile courts under common law, but with the development of the juvenile court, the age limitations decreased. And there's a case that Kent versus United States, 66 case, which stands for that proposition that you children could be tried in juvenile court. In juvenile court, though, the goal is not to incarcerate them or to punish them, but rehabilitation is the main goal. I've already said this before, and I'm on record of saying that I think rehabilitation should be the goal in all criminal cases, but we specifically want to make sure that we're not being punitive when it comes to dealing with juveniles, because we want to salvage them so that they don't grow into adult offenders. And then under certain circumstances with the law now, children can be tried as adults. As I said earlier, there are many violent offenses that are committed by juveniles now, and that because of that, they can be tried as adults. And when they're tried as adults, they're not tried in the civil criminal court, but they're tried in the juvenile court, and we try to keep them in the juvenile court. There are some instances where there is a trial in the adult court, but we try not to have that to happen. It says here that the Attorney General's Task Force on Children Exposed to Violence has released a report that calls for an end to laws and regulations that prosecute children as adults because of the exposure to violence. It's believed that if a child is exposed to violence, they may go out and commit violence. Well, I take issue with that because I stand here today as a person who grew up in a home of domestic violence. As I've shared earlier in the quarter, my dad was killed in front of my face by the guy that turned out to be my mother's live-in boyfriend. And then we spent the next 5 years living under the roof, my sisters and myself, with this man, beating her on a regular basis. So I was exposed to violence almost all the time. And then he finally killed her and left 8 children, 7 girls and myself, without a mother. And I was about 13 years. I was 13 when that happened. But I've never been in any court tried as an adult. As a matter of fact, neither have any of my siblings. Neither have any of my sisters as well. It says more than 200,000 children are tried as adults each year. The youngest children who have been sentenced to life were 13 years old. It's already established that juveniles do not receive the death penalty, and we'll talk about that coming up in a little while, and that the famous Simmons case stands for the proposition that we don't execute juveniles. Okay. Many children tried as adults for violent crimes, as they say, were exposed to violence and abuse at an early age, and the current law ignores social problems. But in 2012, 32 members of Congress urged the then Attorney General Eric Holder to strengthen federal legislation and essentially prohibit states from incarcerating any person younger than 18 in an adult prison. Now, I agree with that because, first of all, number one, when you put a juvenile in an adult facility or prison or jail, you expose them to learn how to become career criminals or to become real criminals, so to speak. And so as a result of that, those individuals don't have a chance to live a life, and it's hard to rehabilitate them in that instance. So it's good to keep them in juvenile facilities. As far as the defense of intoxication, first of all, voluntary intoxication is when you try to use that as a basis for why you did something. But it's not a good defense. It says here in some states it's used to determine whether specific intent of a crime could be formulated, because it will put you in a diminished state where you don't make the best decisions. But most courts reject this defense for general intent. In other words, it might, I should say, mitigate the offense, but it won't excuse you for the offense. Let's put it that way. Involuntary intoxication. Now remember, that was voluntary, where you yourself take the drink and you then commit an offense. And you try to use it. Oh, I was drunk. You can't use that. You can't use that. That's like, think about it. If you're driving a car, you were drunk. Well, guess what? That's not an excuse. In fact, that's a contributing factor to the offense that may be involved in one of those kind of cases. Involuntary intoxication, on the other hand, is when somebody slips a Mickey to you, or it's not intentional. You might take a double dose of your medicine. You might have forgotten. And I've seen that happen with people where they've taken their medication and then they take it later that day and forgot. And, but the key thing there is that driving under the influence of alcohol or drugs is a offense that can land you in jail or with a fine because of the dangers to yourself and others that take place. So it basically removes criminality from the act, and then it puts it in like a civil mode as opposed to a criminal mode. Okay. Insanity. Let's talk about that for a little bit. As I already said earlier, that insanity says that you did a crime, but you lacked the mental capacity or the mens rea to commit the offense. And there are various tests that are used, and they're all very onerous to try to prove. The Norton rule says, and this is one rule that some jurisdictions use, says that at the time when you committed the act, you were suffering from such a serious defect that you didn't know what you were doing. And you didn't really have control of the situation. Now, that test is not applied a whole lot in jurisdictions, especially here in Illinois. And later on, I'm going to share something else with you. There's another rule that came out. But the Durham test says you have a mental disease or defect and did not receive support. So in other words, you were insane because you might have found yourself in a situation where you were in an environment or something happened and your mind was just totally gone. There was a young man who was found not guilty of an offense by a judge because he was never taught right from wrong. They called him, they used his defense as the affluent, affluenza, not influenza, but A-F-F-L-U-N-Z-A. And what they're saying is that this young man wasn't taught right from wrong. And he was very wealthy, and they had a lawyer that was able to present that argument and a judge who bought it as well. Most of us as attorneys, defense attorneys, of which I was for many, many years, argue that doesn't make any sense because that's the same thing that many persons who commit crimes. So the Durham test is not very strong, but look at what happens here. The ALI standard, or the substantial capacity test, which basically goes to say that you were just gone. You were totally gone. And in terms of determining insanity in most jurisdictions, here's the deal. I had a young man who committed an offense. He raped a girl. He had never been in trouble before. He tied her up and then stabbed her multiple times, put her body in a garbage can, rolled her body away to another block. And the long story short, they brought evidence to the house because the garbage can was serial numbered and it traced back to the actual address. Well, after that, they got a search warrant. They discovered that they found the bloody knife and other evidence in the house there. And so I tried to have this young man examined by a psychiatrist, and the psychiatrist came back and said that at the time that that person committed the offense, they understood what they were doing. So in other words, if there was planning and plotting, which this young man did, he knew how to hide stuff. He knew that he had committed something, an act that was wrong at the time. Therefore, the insanity defense was not, no matter how egregious the offense was. On the other hand, what we call there's another test that we used, and there was a young lady whose name escapes me right now, and this young lady was guilty of hanging her child after the child was given back to her by the Department of Children and Family Services. And I saw this young lady in jail, and she was in a corner rocking and shaking and everything. The long and short of the story was, it was established that at the time of the offense, that she actually thought that she was hanging an animal and not a child. And that was proved, and so she was excused of the offense. Now, that didn't mean if she went, free. All that meant is that she didn't go to jail. She went to an institution after that. But the incentive, and so insanity is not that easy. And some states already have abolished it, but it might as well be abolished because it's not applicable in very many cases. Probably less than 5% of the cases where a person pleads insanity ever reach the stage that that person is insane. Psychiatric evidence of impaired volitional control is not admissible as of 1984. Psychiatric evidence may be used to negate specific intent, but not that the crime itself was committed. There must be clear and convincing evidence, and the burden of proof is on the defendant. Okay? But don't count on it as a defense. What you might think would be an insanity defense, a person commits an offense, is not going to fly. Here's an example here. Eric Clark was charged with killing a police officer. He said that the insanity defense was applicable because he was paranoid schizophrenic. Well, the Arizona law did not include part of the Norton rule, which I talked about earlier, in which the defendant did not understand the nature and quality of the act, and he was convicted of first-degree murder. He appealed, and U.S. Supreme Court ruled that the Arizona statute did violate his due process rights, and that states may refuse to allow psychiatric testimony short of insanity to negate mens rea. So said that the statute did violate his due process rights, and that the states may refuse to allow psychiatric testimony short of insanity, not testimony based on insanity to negate mens rea. So basically, in this case here, where the Norton rule was satisfied, then that person was deemed to be insane. But again, don't count on it. There's what we call excuse defenses. Excuse defenses are reasons that you give why you committed the offense, and you should not be held accountable, such as duress. Now, illegal confinement or threat to harm or coerce someone to do something. It must be, we have a thing called gun at head duress, which means there must be imminent jeopardy or danger to someone, that individual that forces them to do it, or someone, their loved one, or someone that's close to them, or something of that nature, or another human being, those kinds of things. Necessity, forces beyond the actor's control, economic duress, has never been accepted. I did it because I needed to eat. I broke in to this place because I needed a place to sleep or stay. It's not going to be an excuse. Consent. Consent. Physical injury consented to must result from the conduct that is not intended to cause serious injury in those kind of situations. But again, not very often applied. Mistake of law. Well, you relied on the law, but you didn't totally understand the law. But there's an old adage, and it's mentioned here, that ignorance of the law is no excuse, and so therefore you can't use that. People have tried to use, oh, I just didn't know. I didn't know. And I'm not talking about like a strict liability offense. I'm talking about in criminal cases, I didn't know that this would be the result if I did this. It doesn't fly. Mistake of fact, innocent misunderstanding of fact rather than from criminal purpose. Now, that could be, for example, somebody is charged with theft, and they pick up a suitcase and they look alike, and they found out later that they had the wrong suitcase. Well, their defense is I didn't intend to, or either I remember a time when I was at someone's house doing some business, and I hung my coat, or they hung my coat in their front closet, and so when I got ready to go, they said, go get your coat in the front closet. So I went and put on the coat, and I put the coat on, and there were two coats that they looked very similar. And so I picked the coat up that I thought was the coat and put the coat on, and then when I reached in the pocket, there was some money in there, and it was quite a few dollars, quite a few bills. And I realized that that wasn't my coat. And so I let the individual know. I said, hey, this is not my coat, and I picked up the other coat. Well, the car keys were not in that coat either. But the point of the matter is let's assume that I had the car keys in my pocket, and I put the coat on, and then I actually left. And then they called the police and said I stole their coat and money, but I left my coat in its place. I could come back and say and prove that the coats were so similar that I didn't realize it. However, though, I could still be charged if it reaches the stage where as soon as I realized, based upon reaching in the pocket or for whatever reason, that that wasn't my coat, that I didn't make attempts to return the proper coat, return that coat back to the proper person. Lambert versus California, the Supreme Court reversed the conviction based on the notion that the defendant must be notified of the required acts. This person was convicted of failing to register with the city as a convicted felon. He didn't know about it. He didn't have any notice of it. He appealed his conviction, stating that his due process rights had been violated, and the court agreed. Because it wasn't a situation where it was known to him. It wasn't, he didn't know that that was a requirement of that city. And then because he had never had prior notice, he appealed his conviction and said his due process rights were violated. Some might argue, well, ignorance of the law is no excuse, but because this would have placed him in a situation where he might have had to go to jail or something, then the court says, no, you need more notice there, or adequate notice. Now, we get to the use of force and self-defense. Force must be reasonable under the circumstances. For example, if a person is armed with a weapon, and it's a weapon that presents a danger to you, then the question is, if you shoot that individual, is that justifiable or not? Well, it depends on what it is alleged to be a weapon. And also, there's no issue about whether or not that individual is holding a toy gun and you're holding a real gun, and that person holds it up and you shoot him, and then later the evidence discloses that that was a toy gun and you shot them. The question is, did you use reasonable force? And the answer would probably be yes. I remember when I was a police officer, a young man confronted me one time, and I didn't have a uniform on. I never wore a uniform because I was in a special unit, and I had a shoulder holster, and I had a young man told me to give him my wallet, and I reached down inside my coat. I said, I'm getting my wallet, and then I pulled out my gun. I had a Glock in my hand, and told him to drop his gun. Well, and told him to kick it. It turned out to be it was a toy gun. I would have been within my rights to have blown him away, literally, with my gun, but it didn't happen but I would have been justified. So when do you use deadly force? When there's imminent danger to someone from an individual. Someone asked a question, if a person's holding up a butter knife and you're able to see that's a butter knife, and then you take a gun and shoot them, then you're probably going to run into a problem. But if a person holds up a butter knife and it's dark and you can't tell, and it's a knife and they're coming at you, then you could use deadly force in a situation like that. So self-defense is an affirmative defense, as I mentioned earlier. And some examples are stand your ground laws. Now, in the stand your ground laws, you must be at a place where you have a right to be there, and you don't have to escape. You don't have to retreat, but you can use the necessary defense of stand your ground if you use the force that's necessary to repel that individual. That person uses their hands and you use a gun, you're going to not be able to use that as an affirmative defense because you will have gone to deadly force. And the old rule of retreat that used to be, that doesn't apply in many jurisdictions anymore. The objective test versus subjective test. The point of the matter is that we look at these on a case-by-case basis and look at all the surrounding circumstances and situations to determine whether or not self-defense. Self-defense can be used to protect yourself or your property, but remember, the level of that force will depend upon the totality of the circumstances or what kind of evidence that person has that they're holding up against you. If someone's holding up like for example, I got my phone here. If I was to take my phone up and threaten and hit somebody with it and they take a gun and shoot me, that's probably going to be an issue. Now, what they might say is, oh, he had a shiny object and those kinds of things. I've heard that and seen that, but doesn't fly very well. Or I thought that the person had something on them. I saw them put their hands in their pockets and they came out real quick, and so I had a second to make a decision about what's what. You better be really, really right about that. As far as use of force and self-defense, battered women and children's syndrome, there's an argument that women who are battered and abused use that as a defense, that they killed the individual because they were constantly subjected to domestic violence. I know of cases where people have, I had a young lady, a friend of mine that I knew, and I didn't represent her, but I believe I could have beat the case. Wanted for her, the individual she was married to was known to be violent, and he was also, I think, affiliated with with the mob or mafia, and he used to beat her frequently. Well, she waited for him to go to sleep one time and then shot and killed him. Well, because of the circumstances, they tried to use the battered woman self-defense, and the point of the matter is that it didn't fly because she wasn't in jeopardy, because then she could have left in those kinds of situations. Same thing as far as children. You know, it said that the child was exposed to violence all the time, and therefore it's not their fault. Again, that goes back to, remember what I said earlier. Well, this doesn't apply, but the affluent defense, because that has nothing to do with self-defense. But let's say, for example, a person is violent because they've been around violence. The argument is not going to be very strong. It might be used to mitigate in terms of the sentencing, but it cannot be used and probably won't be successful in a case. Now, juries are kind of funny about that. Now, if a jury sometimes will come back and find a person not guilty because they empathize with the situation. Defense of others, I've already talked about that, and defenses of property. Those are the bases which you can use that defense. The stand your ground law came popular because of George Zimmerman, it says, who was working as a neighborhood watchman, shot Trayvon Martin, who was walking in the neighborhood. Zimmerman said that Martin had charged him and threatened his life, and that he acted in self-defense. So what Zimmerman had done was watch this young man walk in the neighborhood, call the police to report that he was acting strange. So the police told him to stay away from the individual. Now, he ignored the instructions and approached the individual. To me, that would negate the stand your ground defense, because he was already, the young man, Zimmerman should have stayed away. But in fact, he ignored that. He didn't do it because the young man was creating any dangers to anybody else. And so anyway, he was charged with second-degree murder, and a jury found him not guilty of second-degree murder because of all the total circumstances, because they went into the mental state of Zimmerman and said that he actually feared that he was going to be attacked by this young man. Again, I would say that I still, to this day, have problems with the fact that he ignored the police instructions and approached him. Okay. There's immunity. You can argue that you're immune from prosecution by the Constitution. Again, as I said, there's a privilege against self-incrimination. You don't have to testify against yourself. You don't have to provide evidence. And immunity can be transferred to a witness as well. And there are other forms of immunity, such as contractual, where a person is what we call flipped or turns and makes a deal, and they're putting in what we call witness protection to testify against someone, and that whatever their part in the crime is, they're not prosecuted for that in exchange for helping with the prosecution of that other individual. And usually we operate on the basis of using the terminology, we take the small fries to catch the big fish. In other words, those individuals, for example, who are dealing in drugs in the streets, who are street drug dealers, we want, if we catch them, we want to know who their contact is, who's providing the drugs to them. We're trying to get up far enough to the ladder where we break the chain of the sources that the drugs are distributed from to them. Diplomatic immunity, that means, like, for example, you're a government official from another country, and you can't be tried for that. I'll show you that in a minute. Legislative immunity, legislators, there are certain crimes that they're not held responsible for, especially during the time when they are in session. Now, here's an example of diplomatic immunity where protects this government official from undue prosecution. On January 27, 2011, a U.S. diplomat killed 2 Pakistanis. And this diplomat admitted to shooting the 2 men after they pulled alongside him on a motorbike. And the American official said he saw they had a gun and he thought he was about to be robbed. Well, Pakistan charged him with double murder, ignoring his immunity status because he was a diplomat. He was released from custody after payment of $2.4 million. And so the question here is, should the Pakistani government have charged him? And under diplomatic immunity, the answer is no. Okay. I already talked about double jeopardy. Okay. Statute of limitations. It means what it says. It means that there is a period of time in which a crime can be, you can be prosecuted for a crime. In murder, there is generally no statute of limitation. That is why many, many years people have been found guilty of murder. Years, even years and years have passed. Because there is no statute of limitation. Federal statutes are 5 years for non-capital offenses. Every state has different limitations depending on the jurisdictions. And some states have removed limitations for rape. Why? Well, for a number of reasons. First of all, number one, with the individuals who are raped, it's been discovered that it is a crime, first of all, that that person is humiliated or embarrassed oftentimes when the charges are brought forth, or there are questions about themselves that might come out that they don't want to come out in these instances, and they may believe that what the rapist said and not them, and those kind of things. Defendants can waive the right to the statute if they need to gain time for plea bargaining. Now, if you, for example, engage in plea bargaining, the time for the statute of limitations stops as long as you're engaged in that, or either if there's some investigation. But it starts back up once you say you're ready to proceed with a defense. But anyway, my point being is that back to the rape instances, is that it takes sometimes a long time for individuals to come forth. And there's been some help with the rape shield laws that have helped to make individuals feel a little bit more comfortable, but it's still a crime that makes the victim very, very uncomfortable. Therefore, there have been limitations. You also are aware that there have been times now that priests have been found guilty of committing crimes after many years have passed, but usually what they end up doing there is not go to jail. There's usually a civil suit that's filed. And the reason why that is because there's that limitation on the criminal act itself. Entrapment. This is when the government, when someone is minding their own business and the police or law enforcement trick someone or induce them to commit a crime that they would not be doing. In other words, they mind their own business and they dangle something out in front. Hey, you're walking down the street and somebody approaches you, says, hey, you know, got these drugs. Now, hey, they may or may not know that you are a person hooked on drugs, or that you one who stand that you're weak and that kind of thing. Well, there's an argument of entrapment if that person was minding their own business. But let's say, for example, that if someone is looking for drugs and then they buy it and it turns out to be an undercover officer, that's different, because then that person was not being induced to commit the crime. They were just looking for a place to get it, and that's the difference. At common law, there was no such thing, and it's still not even in the Constitution, but you hear entrapment being used. Now, the subjective test of entrapment has a problem that it does not establish rules for enforcement for police. So it's all determined on a case-by-case basis, put it like that. Objective test of entrapment, where a court establishes police used improper methods to get that individual to commit the offense and then put cuffs on them and then lock them up, those kind of things. In the Jacobson case, where the Supreme Court reversed his conviction for solicitation of sexually explicit materials, arguing that the government agent may not implant a design in the innocent person's mind. In other words, put the idea in the mind of that individual. And what happened is Jacobson, he was a convicted sex offender. It's like I said, if a person is known to be hooked on drugs, and the police might try to trick them into buying drugs and those kind of things. But anyway, this person was targeted by police and received mailings of sexually explicit material over a period of 26 months from the police. And the mailings also included communications decrying censorship and questioning the constitutionality of the government's efforts to restrict sexually explicit materials. So it was reversed because they were like, how should I put it? If a person has a sweet tooth and you're constantly putting sweets in front of them, then you're tempting that individual, and you're doing it on purpose because it will draw them in, and that's kind of like what happened here. And you can't do that. That's when you get into entrapment. Selective prosecution, that means that you are prosecuting a person and another person of a different race, religion or other class commits the same offense, but you don't prosecute them, but you prosecute the others because it's based on their race, religion, or other impermissible classifications. Such as if a person is African American, commits an offense, and then there are Caucasians who commit the same offense, and you don't prosecute them, but instead you prosecute the African American. Or a person has a religion, they're a Muslim or something, and you don't prosecute the Christian who does it, but you do that. Or they're from another country, or one of those kind of situations. But the defendant has the burden, though, of proving that other similarly situated persons have not been prosecuted for the same conduct. In other words, must be able to prove that that pattern exists. And it's rarely used, and it's oftentimes rejected. United States, in this Wright versus United States, held that passive enforcement of prosecuting only those non-registrants who reported themselves or reported by others was not violating the First or Fifth. This person had not registered for selective service and was convicted. Well, he argued that there are other people who didn't. That's different. That's different. That's just like I had, when I was a prosecutor, I had people who came to court for, brought to court for speeding, and their defense was that others were speeding along with them, and that they were singled out. And so the judge said quickly, this is not about them, this is about you. And so because you got caught, they didn't, there's not violation of the First or the Fifth Amendment. You're not being picked on because we don't know you. We just saw someone speeding and you got stopped and you were found, you were caught speeding. There's some, final thing is there's some novel defenses and innovative defenses which don't fly very often. And, you know, people try to use some of these, their religious beliefs, don't try to use that. Victims' negligence. I've heard people try to use in rape cases that the female was dressed in a suggestive fashion, not good. I've heard and seen in cases where females are involved that they tried to use their premenstrual syndrome or PMS as a defense, saying that they were out of control and that's why they did. They were violent as they were, not going to fly. Compulsive gambling, it's not going to fly. Now remember, these things may be used to mitigate in terms of the offense, but are not defenses to committing the offense. Post-traumatic stress syndrome, same thing. Junk food defense, that because the food that you intake, you committed offenses because the food took control of your system, not going to fly. Television intoxication, all you watch is violence and violence, so therefore you become violent. Pornographic intoxication, same thing. I did it because I'm a junkie on pornography. That's why I raped that person. That's why I did that. Not going to fly. And then the infamous XYY chromosome abnormality. In other words, it's genetic. That's why you committed the crime. Not going to fly. So those are some what we call novel and innovative defenses. But you will find that it's just like that other one I told you, that affluency was a novel defense. But here's the deal. I would say not going to fly, but the thing about the law is that we learn as defense lawyers that we can try whatever, even no matter how ridiculous it might appear. Even people might laugh at you, but then a person can be found not guilty if you get the right judge. And so as a result, if that takes place, then that person is tried, they're found not guilty, and then the defense state can't come back and prosecute because of what we talked about earlier, the double jeopardy rules. And that's it for this chapter. I don't have anything else. We do have one more lecture, and that lecture will be in week 10. And so at that particular time, we will conclude with the lecture series for this. And so, again, I'm going to say good night to you, and I'm going to terminate the meeting.